But the court has been quite consistent, as you suggested, until this very day in adhering to the consumer welfare standards, sometimes expressly repeating itself, other times restating the matter in terms of the purpose being to preserve competition, not competitors, which was a hallmark of the Ancien Regime before the book, preserving competitors for a variety of ill thought out reasons. And the critiques that we're hearing now from, not from within the courts, of course, but from a variety of academic and academic and then outside public policy commentators has been really an invitation to return to our old ways, to return to an era when it was really impossible to anticipate how the court would apply the antitrust laws, with one exception, as Justice White pointed out. The only consistency in the merger cases there was a plethora of them in the 60s, was that the government always won. That was not a very good way to develop jurisprudence, having multiple different, often one-off rationales, but at the end, the government always won. It wasn't exactly informative for business as to what they could and couldn't do, except that they might individually, some firms proposing a merger might find themselves struck by lightning when the FTC or the Justice Department steps in and say, no, for some reasons which are hard to explain, but we'll think of them, we oppose your merger. But of course, this is not just all about mergers. The consumer welfare standards really been very influential with regard to Section 2 of the Sherman Act, not just Section 1, dealing with monopolization and attempted monopolization.